Good afternoon, everybody, and welcome to today's webinar, which is on unfair dismissal. I'm Anna from the TUC, and I'm really pleased to be joined by Joe and Gerard, both from Thompsons Solicitors, who are going to be talking to us about this issue. I'm going to be handing over to them in a second, but just a couple of housekeeping things before we get going. Firstly, welcome back. Or welcome to our webinars. This is our first webinar of 2021. We've had a bit of a break. Hope you all had a nice festive season, although albeit very different from what we're all used to. So this is the first in a series of webinars for this year. And we've got a great lineup planned, so do keep coming back. First of all, we do have live captions for today's webinar. There's a green button at the bottom of the screen that says open live transcript. So if you do want to watch with the captions, please do that. Please click that button. It's great to see so many of you already introducing yourselves in the chat panel on the right-hand side. So please carry on doing that. My colleagues, Alice and Ian, will post any links to any resources there that are relevant, but it's great to see so many of you already getting involved. If you want to ask Joe or Gerard a question, down at the bottom of the screen, there's an Ask a Question button. Please post your questions there. We'll try and get to as many of them as we can during the live session. But we do think this is an incredibly popular webinar. We've got a record number of people who've registered for it, so we'll try and answer as many as we can. And another special thing about this webinar, for the very first time, if you join this webinar live, you will get a digital credential to say that you've watched this webinar. It will come in the form of an email with a digital badge in it. So do keep a lookout for that. We're really excited that we're awarding these digital credentials for webinars now, because it's evidence for you of some training that you've done, and it will show what you've learned. So do look out for the email, and when you get the email with the badge in, please accept the badge and share it. Show off what you've learned, show people what you know about this subject. So I'm going to hand over first of all to Joe, who's going to talk us through unfair dismissal and some of the things that you as a workplace rep need to be aware of. So Joe, over to you.
Oh, thanks very much, everybody, for inviting me. I'm really pleased to be speaking at this webinar, and I'm just going to give a very brief overview of the law on unfair dismissal and try and squeeze in some pointers when you're representing your members at a disciplinary or dismissal hearing. So I understand you've got plenty of time to ask questions, and I'm sure that you will. So employees can bring a claim in an employment tribunal if they have been unfairly dismissed. So the first thing to consider is, what is a dismissal? Well, a dismissal occurs where the employer terminates the contract of employment, either with or without notice. So if the employer terminates the contract of employment and then issues the employee with another contract of employment, then that still will be a dismissal, even though the employment relationship continues. A dismissal will also occur where the employer doesn't renew somebody's contract who's on a fixed term contract. So in those circumstances, the contract will come to an end when the fixed term comes to an end. Another time when an employee might be dismissed is when the employer refuses to take the employee back to work at the end of maternity leave or any other family leave, in circumstances where the employee actually wants to return from the maternity leave. Now, whether the reason for dismissal is fair or unfair is obviously at the crux of this talk. And we first need to consider, who does the law on unfair dismissal apply to? Well, the first point to make is that it only applies to employees. And employees are those who are employed on a contract of employment. It therefore doesn't apply to agency workers and those employed on a casual or 0 hours contract. Also, employees have to have 2 years continuous service with their employer in order to qualify for the right for unfair dismissal. But there is an exception. So employees don't have to have 2 years continuous service in order to bring a claim if the reason is an automatically unfair reason. This is because employees do not have to have 2 years continuous service, provided the principal reason for the dismissal is an automatically unfair reason. So, what are the automatically unfair dismissal reasons? These are, briefly, if somebody is dismissed on trade union grounds, if somebody is dismissed for health and safety reasons, because the employee took maternity leave or other statutory leave, and that was the principal reason why they were dismissed. If the employee made a protected disclosure or blew the whistle, which is more commonly known as, or if they enforced their rights under the national minimum wage, or if the principal reason for the dismissal was because they asserted their rights under the working time regulations. So, for example, if they refused to sign a workforce agreement, which reduced their rights under the working time regulations. And finally, an automatic unfair reason will be where there has been a transfer of the business, and the transfer is the reason or principal reason for the dismissal. Now, there's just one important point to make about dismissals for a TUPE reason, for a transfer reason. In that case, the employee does have to have 2 years service. So in all the other examples I gave where somebody is dismissed on grounds of health and safety or because of trade union duties or taking maternity leave, then they don't have to have 2 years service. TUPE is a bit of a quirk of the automatic unfair dismissals where the individual still does have to have 2 years service. And another automatic unfair dismissal reason is where the employee can show that the principal reason for the dismissal is because they asserted a statutory right. So an example of that would be where somebody was dismissed because they had brought a claim for unlawful deduction from wages before they were dismissed, and the employer didn't like that and sacked them for it. That will be a dismissal for asserting a statutory right. So, what is an unfair dismissal? Well, the law sets out 5 fair reasons an employer can dismiss an employee. These are conduct, so examples might include disobeying a reasonable order, dishonesty, theft, unauthorised absence from work, violence at work, drug and alcohol abuse. Those are some examples of conduct. Capability. This is another fair reason, and this applies where the employee has been dismissed either due to poor performance or as a result of ill health. So, for example, where somebody has been dismissed as a result of being on long-term sick leave and is no longer capable of doing their job. The third reason is redundancy. Now, the law defines redundancy as occurring where the business closes, the workplace where the employee is employed closes, and there has been a diminution in the requirement for work to be done by a number of employees, so where fewer employees are needed to do the work available. The fourth reason is breach of a statutory duty, and this means where the employee cannot continue to work without contravening the law. The most common example is whereby the employee loses their driving licence and they're required to drive for their job. That would be an example of a dismissal for breach of a statutory duty. And then there is the fifth reason, which is a bit of a catch-all reason. That says that where the employer can dismiss somebody for some other substantial reason, commonly known as SOSR. This most commonly arises where the employer has a business reorganisation and then issues employees with notice of dismissal and re-engagement on different terms and conditions, something that comes up quite a lot lately. So if the employer dismisses for another reason, so it doesn't fall into the category of one of the 5 reasons we've looked at, conduct, capability, redundancy, breach of statutory duty, and some other substantial reason, then that will be unfair. Generally, the employer will set out what the reason for dismissal is in the dismissal letter. Where the employer doesn't provide the employee with a dismissal letter, then an employee has a right to a written statement from the employer setting out what the reason for the dismissal is. So they should request that from the employer, and then the employer has got 14 days in which to reply. If the employer doesn't reply and the employee brings a claim for unfair dismissal, then they'll be entitled to 2 weeks additional compensation. So it's not enough for the employer just to identify what the fair reason is for dismissing. The employer has also got to act reasonably when dismissing for a fair reason. So how do you know? How do you know when an employer has acted reasonably? Well, the typical lawyer answer might be, depends on the facts and circumstances of the case. And that's right, a tribunal will focus only on whether the employer acted reasonably. And they won't take into account any injustice to the employee. The main purpose of the tribunal, they have got to decide whether the dismissal was within a range of responses a reasonable employer might have adopted in the circumstances of the case. Now that gives the employer quite a fair range in which to determine what is reasonable, because actions of a reasonable employer might not be what you or I consider to be reasonable, but they may be what a tribunal finds a reasonable employer would have done in the circumstances. And this also means that the fact that a reasonable employer may not have dismissed doesn't necessarily mean that the dismissal is unfair. Now, case law has developed certain general principles that apply to each of the fair reasons when determining if the employer has acted reasonably in each case. So we'll look at those now. In the case of conduct, for example, an employer will only act reasonably if they can demonstrate that they have a reasonable belief in the alleged misconduct. So, for example, if the employee is alleged to have acted in breach of the company procedures, the employer must have a reasonable belief that the employee breached the company's procedures. And that belief must be based on reasonable grounds. Reasonable grounds are established after the employer has carried out a reasonable investigation. The more serious the allegation, so in a case of dismissal, the courts consider that that's a serious allegation, then the more thorough the investigation should be. And employers are also required to carry out an investigation where an employee might be dismissed from gross misconduct. And this is important because there may well be mitigating factors that need to be taken into account where an individual has been dismissed summarily without notice, i.e. gross misconduct. In the case of capability, an employer will only act reasonably if the employee is informed of the standards of performance that they are expected to meet, and they are warned by the employer that they are not meeting those standards, and then given a reasonable opportunity to improve. So those are the tests that apply there. In relation to capability on health grounds, then to act reasonably, the employer must consult the employee to get their view on any medical condition, and also to identify whether or not there is an underlying condition. The employer must also obtain medical evidence. Now, this will usually be a referral to occupational health, but this will often depend on what's set out in any agreed capability procedures that the union may have negotiated with the employer. And the employer is also required to consider alternatives. Now, in a case where somebody is on long-term sick, they may well have a fit note in which the doctor or GP or consultant or whatever has set out recommendations in the fit note. This might be that the employee should avoid heavy lifting or avoid standing for long periods of time, or recommendations that they don't work at certain times of the day. So the alternatives that the employer must consider should take into account any recommendations that are made in the fit note. Similarly, if when they have spoken to the the individual about the reasons for their long-term sickness absence or their medical condition, and they establish that they have a disability, then the employer may be required to make reasonable adjustments in order to facilitate the employee to return to work. In a case of redundancy, the law makes it clear that whether an employer has acted reasonably will depend on whether or not the employer has warned and consulted the employee. There are particular additional responsibilities on an employer to consult where employees are proposed to be dismissed for redundancy by the employer. In that case, then there is an obligation on the employer to collectively consult with the appropriate representatives. But what I'm looking at here is the individual unfair dismissal case. And again, even where the employer has consulted with the union, they still must consult with the individual, because the purpose of the consultation in a redundancy situation is to enable the employee to challenge their selection for redundancy or to raise any other issues about flaws in the procedure. The employer, after warning and consulting, must also apply a fair selection criteria. So the selection criteria should generally be objectively justified, assessed, and fairly applied. And finally, the employer should also consider suitable and alternative employment. Turning now to the test of reasonableness in some other substantial reason, the employer should consult employees and consider suitable alternative employment. Now, where the employer dismisses and re-engages new employees on new contracts of employment, the employer must also act in accordance with equity and fair dealing. And this is, I think, important in these types of cases, because what this means is that the employer who dismisses employees who refuse to accept changes to their contracts of employment, a factor that the tribunal will consider will be whether or not those changes have applied right across the board, and that they're not just concentrated at one level of staff. So that is another factor that the employment tribunals must consider when determining whether or not the employer has acted reasonably. Now, in all cases, the employer must follow a fair procedure. In workplaces where the union is recognised, there will usually be agreed disciplinary and dismissal procedures, as well as other relevant procedures. So there may be capability procedures, sickness absence procedures, redundancy procedures, which the union has negotiated. There's also the Acas Code of Practice, which underpins most disciplinary and grievance procedures, and the Employment Tribunal will take into account whether or not the employer has complied with the Acas Code of Practice. And what that says is that the employer must establish the facts of the case by carrying out a reasonable investigation without unreasonable delay, inform the employees of the problem, so give the employees enough information so that they can gather evidence to defend themselves, hold a meeting to discuss the problem at which the employee must be allowed to be accompanied, decide what the appropriate action is, and this might include a first warning for a first offence, and then provide the employee with an opportunity to appeal. Now, just turning now, because I'm conscious I'm going on time, but what I wanted to just do very quickly is to give you some pointers to take away when acting on behalf of your members. So I've prepared myself a little checklist that I want to take you through. The first is, make sure you understand what the reason for the dismissal is. Sometimes they're couched in very general terms and it's not always clear. You know, are you clear what the reason for dismissal is? Are you clear what conduct's being alleged, what the capability issue is, and where the employer is saying some other substantial reason? What is that? Have you got all the evidence you need? Be prepared to say how relevant it is. So if you've got an employee, for example, who's alleged to have made defamatory comments about the company's health and safety on a Twitter account, and they deny that they've got a Twitter account, then relevant evidence will be whether or not the employer has interviewed other employees. 3, focused on your best arguments. So in the example that I've just used where the individual raises have a Twitter account, but the reason that they raised them on Twitter was because that the employer was ignoring their concerns and did nothing when they raised it, then the relevant evidence will not be denying that the individual's got a Twitter account, because that's just a waste of time, a waste of your time. You're better to focus on gathering evidence of when the individual raised the complaint and the fact that the employer did nothing about it. Where dismissal is due to ill health, consider whether or not your member has an underlying disability and whether or not the employer's got obligations there. Reasonable adjustments. If the employee there's no prospect of them returning to work, then the employer should also consider whether or not the employee is eligible for ill health retirement. And the fifth point I wanted to make was, don't hold back on arguments that at the appeal stage, thinking that they are a golden nugget and you've got the employer banged to rights when you get to the employment tribunal. So if, for example, you find out after your member has been dismissed that there is medical evidence which shows that actually they could return to work, then you should raise that at the appeal stage. This is because the employment tribunal will assess whether or not the employer has acted reasonably in dismissing your member based on all the facts that the employer knew at that time. So that counts right up into the appeal stage. Even though they've been dismissed, the appeal is part of that disciplinary process. So it's really important to include all that evidence. I hope those pointers are helpful, and that's all I wanted to say for now on the matter. I'm sure you've got lots of questions.
That was brilliant, Jo. Thank you so much for that really informative outline of unfair dismissal and the things that workplace reps need to be aware of. It's great to see so many questions coming in. As I said, we'll try and get to them after Gerard said a few words. I'm going to hand over him in a second. I can see a couple of comments in the chat panel saying that you maybe some of the transmission from Jo, if you've got bad connection, you don't quite catch everything. There can be a number of things that are causing that, but do remember you can open the live transcript. In general, it's all coming through well, but there are a lot of you online, so just please do bear with us on that. Okay, I'm just going to hand over now to Gerard, who's going to take us through a couple of other legal issues that could be important to you in your role as a workplace rep. So over to you.
Thanks very much. I'm Gerard Stilliard. I'm the head of PI strategy at Thompsons, normally based at Congress House, although sadly stuck in these four walls for the minute. I'm just going to give a quick update for you on where we're at with personal injury claims relating to COVID and people who've contracted it, possibly in the workplace. So I'm just going to set out a few basic principles for bringing those claims, some of the practicalities, and then just wrap up with a few comments on the current position. So first of all, in terms of the principles of bringing a PI claim, the first thing to be said, I suppose, is that you can. It is possible to bring a claim for the contraction of COVID against your employer. And at Thompsons, we've seen hundreds of inquiries already, stretching from people who thankfully have recovered quite quickly from COVID to people sadly suffering from the really serious and quite varied symptoms of what the medics are calling long COVID. And then inevitably, of course, a few cases where people sadly haven't survived their contraction of the illness. So in order to bring a claim, we need to establish a few basic things. First of all, that the employers have breached their duty in some way. And primarily what we're seeing is that people haven't been provided with the correct personal protective equipment. So that would be in breach of either the COSH regulations or the PPE regulations, or perhaps just common law, depending on the nature of the work. We're then having to establish causation. And what that is likely to mean, we'll need to thrash this out because, of course, it's all new, but it's likely to mean that we have to show that it was more likely that a person contracted COVID at work than anywhere else. We're never going to be able to show, except in very extreme circumstances, that it was definitely the case that somebody contracted COVID at work. I can't think of an obvious example where that would be the case. So the law recognises that and puts a different burden of proof, which is that we have to show that it was more likely than not that it was contracted at work. Now, in terms of the practicalities, clearly some workplaces are going to be much easier, much more fertile ground, if you like, for bringing a COVID claim than others. And a couple of distinctions, which perhaps obvious, but I think are worth mentioning. So, some employers, for instance, in the health and social care sectors, know that they are exposing workers to the virus or to the risk of the virus. I mean, the extreme example of that would be somebody working on an intensive care unit, which is 100% COVID patients. And those employers, they know what the risk is. It's pretty obvious to them. They've then got to do what they can to reduce that risk to the lowest practicable level. And the cost regulations will apply. Some employers, though, don't know, although perhaps they should, that they're exposing workers to an increased risk of contraction of the virus. And I think that's probably really key to the kind of workplaces where people are being asked to go back to work, not perhaps in this immediate lockdown, but it'll be soon. And I'm thinking about people like in manufacturing, in education, in construction, where either they've been working throughout or they're likely to be asked to come back. And there, the civil service is another example where the focus will be on the employer knowing that there's a possibility or an actuality of people in the workplace already having COVID. What are they doing to implement all those control measures, social distancing, hand washing, face masks, all the rest of it? What are they doing to protect other workers from the risk of contracting the illness? There may be people who've brought it home and infected family members, a little bit like we saw with asbestos on overalls, people bringing COVID away from the workplace and introducing it into the home. So we've done a lot of work with various unions to set up questionnaires for their members to complete. And where we receive that information or where people are just simply phoning us, contacting us, we're advising them on the specifics of a claim. And where they're simply recording exposure or poor practice, we're maintaining that on a database. We're trying to build up knowledge, keep that within the union movement, and building up the picture of how COVID is affecting people. We've made a number of claims for people in, I think, 3 or 4 different unions now. They cover a large number of industrial sectors, public and private sector. We haven't had sort of substantive responses yet from the employers, but that's something we're going to be hopefully addressing in the next month or two as those responses start to come back. We probably won't be seeing too many admissions of liability, but we'll be able to see where the battleground is, how these cases are going to be fought. And we're going to adopt a cautious approach because the cases are not going to be easy to win by any means, but progressive and trying to push this forward. We're mindful of the fact that we might be bringing claims against the NHS, for instance, and we've got to be sensible in the way that we do that. And we're going to do it in a way that tries to avoid the Daily Mail making some crazy idea that this is a gravy train or compensation junket. These are people who've suffered as a result of their work, and if their employers have been negligent, then they'll be entitled to damages. So hopefully that was useful, but if you've got any questions for me, and they're not all just for Joe, then I'll be here. Thanks very much.
Thanks so much, Gerard. It was really helpful to hear what some of the new potential cases are with this new virus, because I'm sure it's an ever evolving area, and think aspects of the law that reps perhaps need to be aware of. So, turning to questions, we've had a huge number, and as I said, I'm going to try and get through as many of them as we can. So we've had quite a few questions that that cover sickness absence. So, Jo, could you perhaps say a little bit about sickness absence and excessive sickness absence in relation to dismissal, and what some of the things are that reps need to think about in this area, please?
Right, well, I suppose the first point to make is that the employer should consult with the employee about and get their view about the medical evidence. I mean, that's vitally important, and establish if there's an underlying condition. It's the best opportunity to try and find out whether or not your member has a disability, and whether or not there are further obligations on the employer to make a reasonable adjustment. If a person has a disability, as defined, if they've got a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So that's the definition in the Equality Act. If they're put at a disadvantage, so there's a prospect of dismissal because they've been on long-term sickness absence due to their disability, then the employer will be under an obligation then to make reasonable adjustments to enable them to come back to work. So that might be, you know, a phased return to work, adjustment of their duties, adjustment of their working hours. The focus should be on not putting the disabled worker at a substantial disadvantage, and looking at that. If the employee is dismissed because of long-term sickness absence and it is related to disability, then the employee might have a claim that they have been discriminated against for a reason arising as a result of their redundancy. The employer will say, but that will still generate a claim that the employee has been subject to discrimination arising in consequence of their disability. Had they not had the disability, then they wouldn't have been off sick, and then they wouldn't have been dismissed. So in those circumstances, it is open for an employer to argue that they were justified in dismissing them, but they need to be able to show that they had also made reasonable adjustments, because the focus of that is to try and create a level playing field for those who have got a disability. For those who don't have a disability, then the focus should be on whatever is in the sick note about any recommendations and the obligations on the employers to do everything that they possibly can to avoid dismissing them. The employment tribunals will take into account how long can an employer wait before they actually dismiss the individual, and what alternatives has the employer considered as part of the reasonable test when determining whether or not somebody has been unfairly dismissed and they don't have a disability in long-term sickness absence. And then if I can just say one other thing, it's obviously a big topic this, but one other thing that I want to say is that one possible reasonable adjustment might be in relation to the triggers. So this is where somebody has been off on long-term, well, it doesn't necessarily have to be long-term sickness absence, but a reasonable period of sickness absence. And then under the procedure, it says something like, well, if you have had more than 5 periods of sickness absence in 12 months, then you will go to the next stage of the capability procedure. Now, it may be possible to argue that those triggers put the people with a disability at a disadvantage, because they're more likely to hit those triggers and they're more likely to be at risk of being dismissed. And if that happens, then it's a potential argument to say that those triggers should be adjusted. But those triggers will only be adjusted if there's a potential for the individual to return to work. In circumstances where there's no prospect of an individual being able to return to work, no matter what adjustments are made, then it's likely that a dismissal would be fair in those circumstances.
Thanks, Jo. I hope that was some really helpful information there, and I hope that covered the questions that people had asked. So we've got a question now that I'm going to put to you, Gerard. So someone has asked, can you claim personal injury if an employer allows someone who should be isolating into work, or if their policies aren't clear enough, and that they fall into this isolating category, so that employees come into work with people who are symptomatic or indeed asymptomatic, and then that leads to someone contracting COVID?
Yeah, it's a good point. And I think there are a lot of people who have vulnerabilities, not what would be classed as a disability, perhaps for the Equalities Act or for that sort of discrimination, but nevertheless are factors about individual people which will make them more vulnerable, more susceptible to contracting COVID, or for it to be more serious if they do contract it. And what that all boils down to, I think, in health and safety terms, is risk assessment. And risk assessments have to be adequate, and they have to be suitable. And that means that they have to be tailored to some extent to individuals. And where individuals are, where an employer is aware that a person is vulnerable for some particular reason, then that needs to be factored in. And if somebody is saying, I can't come into work because the risk of contracting the illness is so great, given my personal circumstances, then if they do contract it, we've still got to establish that the employer has breached their duty in some way, and we've got to establish that the person has actually contracted, or likely to have contracted, the condition at work. But in those circumstances, yeah, there certainly is a potential for making a claim.
Would that also apply if we're talking about people who aren't in the vulnerable category? So if someone has COVID and they're not isolating rather than shielding it, they should be isolating, but they're still coming to work, and then they infect a colleague?
Yeah, I think it does become a bit tricky then sometimes, because it's a question of the employer's knowledge. And I think, employers can't turn a blind eye to things. We've seen cases in the care sector, for instance, where employers have been condoning, if not encouraging, people to come into work when they've got symptoms that indicate that the person may have COVID. If that's the case, and they're coming in and infecting people, that there's potentially a strong claim there. But to go back to Joe's point, being a lawyer, we've got to look at the facts of the individual cases. We really do have to do that. But it certainly is something that could potentially lead to a successful claim.
Thank you. Okay, Joe, in your presentation, you mentioned the various categories of what would make a dismissal fair or unfair, and you mentioned SOSR. One of our viewers has asked, can SOSR be seen as a catch-all category, or is it more specific than that?
Well, generally employers view it as a catch-all category, but there are, there are some limitations, and the courts have been quite clear really and said that, this isn't something that the employer can just post on. So they can't just say, oh, well, there's a breach of trust and confidence, that's why I'm dismissing you, that's some SOSR reason. The courts are quite clear that actually the employer can't just stick SOSR on everything. There must be some sort of underlying reason. Examples are where there's a business reorganisation. It might be persistent absenteeism, somebody who's not got an underlying condition, but somebody who is, say, frequently takes the Mondays off or whatever, and there's a pattern there. That might cover SOSR. Breakdown in working relationships, not a personality. Dismissal for a personality won't come under SOSR, but where there is a breakdown in the working relationship so that people can't continue to work together, that might be an SOSR reason as well. But, it's not something that the employer can just slap onto anything they like and say, oh, there's a breach of trust and confidence there, you're sacked for SOSR. The courts will come down pretty heavy on the employer on that one.
Thanks, Joe. That's really helpful. I've got a question for both of you, but it's the same question, but I'll stick with you to answer it first, Joe. I appreciate it might be a bit early to tell, but in both areas of law that we've talked about today, Do you think there'll be any changes in these areas with the UK leaving the EU?
Right, well, in relation to unfair dismissal, then no, because that is domestic legislation and it's not really influenced by EU law. So we've got the laws as it is. You know, arguably the law is not as good as it should be. I'm sure everybody would agree with me on that. You know, we had the increase back in April 2012 from 1 year qualifying period to 2 year qualifying period in order to claim unfair dismissal. So, you know, government's got plenty of scope to do what it likes on domestic legislation. And we've heard in the press very recently about rumblings that the government has always hated the working time regulations, and we all know that, you know, the unions represent all these fantastic workers in the care sector, in the NHS, who are really dependent on the working time regulations, and the government has already started making noises about looking to relax that, because the working time regulations did come on the back of the working time directive. So I think we're going to be looking at this area and advising unions a lot more on what we can do in relation to trying to resist some of these changes, and that might not necessarily be legal action, but, you know, Thompsons as a campaigning firm will be joining together with that, and we're very much we've just put a briefing out, if I may do a plug, on the impact of EU our withdrawal. So that might be something you want to look out for.
We just lost you there for a second, Joe. What is it that Thompsons have recently put out? Is it like a call for information or something? We lost you for like 2 seconds.
Sorry, we've done a short briefing to unions' head offices on the impact of the statement that was made by government the other day about their proposals on working time regulations. So we'll be, you know, working together with unions on trying to resist those changes.
That's really helpful, Joe. So we should all keep a lookout for that. Gerard, what about in personal injury area of law? If you envisage any changes as a result of the UK leaving the EU?
Yeah, I don't think anything's going to happen overnight. You know, it's not that the law has suddenly changed, so that, for instance, the parts of our health and safety law which derive from European directives, that they're not going to go away. I mean, frankly, they've already been watered down. Whilst Britain was in the EU, the Enterprise and Regulatory Reform Act, Section 69, which meant that breaches of regulations no longer led to civil liability. You know, that happened while we were in the EU. So it's not a sort of a black and white thing, but what will happen over the coming years, if there is this you know, race to the bottom as we fear, then clearly that does have the potential to impact things in the longer term.
Thank you. This might be a subject I think that we have to keep coming back to over the coming months and years, because yeah, like we don't know at the moment, but that's not to say things won't be different in a few months. Okay, so next question for Joe. We've had quite a few questions mention Section 44 of the Health and Safety at Work Act. What is the probability, or is there even grounds for being dismissed if we refuse to work after quoting Section 44 because workplace is unsafe?
Yeah, so, well, there are two different provisions. Section 44 refers to where somebody is subject to a detriment because the employee reasonably believed that they were in serious and imminent danger, and which they could not have reasonably expected to avert themselves, and they left or refused to return to the workplace or part of the workplace. There is a separate provision, which is Section 100, where somebody is dismissed on those grounds. So the Section 44 relates to where somebody is subject to a detriment because they refused to return to the workplace because they suspected that they were exposed to serious and imminent danger. And then the Section 100 is where they've been dismissed because they've refused to return to the workplace because they thought they were at serious and imminent danger. And I think that it's right that, you know, where Gerard's talked about, the obligations on the employers to make their workplaces COVID secure. And I think the crux of this is whether or not somebody is exposed to COVID in the workplace and the employer has failed to make their workplace COVID secure. In those circumstances, then it will, and the individual says, I'm not coming back to work, and the employer says, well, fair enough, we're going to not pay you, then that might give rise to a Section 44 complaint. It's going to be more tricky if the employer has taken steps to make their workplace COVID secure. And it will always depend on the facts and circumstances of the case, the extent to which the employer has made those adjustments and the extent to which, the individual is exposed to COVID in the workplace.
Thanks, Jo. That's really helpful there. So, Gerard, we've had a question that references teaching assistants in schools, but I think this probably could be applied to other workplaces where there is close contact between different people in a similar kind of situation. So the person who's asked the question is saying teaching assistants are working very closely with children. Could they have a claim for PI if even though they have been given PPE in that situation? What would someone's rights be there? Would they have a legal recourse?
Yeah, well, again, it's tedious to say it in a way, but it is a question of what's reasonable. And I think in the school environment, that's perhaps more difficult. Employers have a genuine difficulty perhaps in working out what the risk levels are and what the control measures ought to be, perhaps more than in many other workplaces. But there's a spectrum. On the one hand, if lots and lots of staff are falling ill with COVID and lots of children are isolating, often of course children being asymptomatic, but are going home and their parents and their siblings are falling ill. If you've got a situation like that, then it isn't safe for that school to be open, in my view. And I would imagine that if a school remained open in those circumstances, a judge wouldn't have too much compunction in finding that the employers have been in breach of duty. Bringing a claim, and this is where some of the difficulties arise in this context, I think, where the individual school, or for instance, the individual hospital, is following national guidance. And as long as they are doing that, as long as the national guidance isn't obviously wrong, it's a pretty good defence for the head teacher, for instance, to say, well, look, I was just doing what I was told. If I hadn't kept the schools open, we know bloody Gavin Williamson would be bringing a JR against him because, to keep it open. They are to some extent stuck between a rock and a hard place, but there will be circumstances where if the risk is clear, then simply wearing a mask or something like that is not going to be adequate protection for the worker.
That's really helpful, Gerard. Thank you. And I guess, like with so many things, it all depends on the facts of the case and the situation itself. But it's still really helpful. Okay, I've got a couple of questions for you, Jo. I've kind of combined a few to try and cover as much as we can. What is the situation if someone is unfairly dismissed? Whether what rights they have if they don't have the required 2 years of service? Is there any way that they can take it further? But if they can't do anything, does that mean the employer can just sort of dismiss someone without any repercussions? And perhaps could you say something as well about probationary periods, because that would often cover maybe not 2 years. It would be a smaller amount, a lesser amount of time, but the whole 2-year rule and what recourses are open to people. Yeah, so if you haven't got 2 years service, we looked at the
at the beginning about whether or not the reason for the dismissal was an automatically unfair reason. So the health and safety ones that we've just been talking about, the section 44 and the section 100, then that would be an automatic unfair reason for dismissal, and you don't have to have 2 years service for that. If you blew the whistle, then you might be able to bring a claim for unfair dismissal for that. So it's going to depend on the reasons. Another example would be where somebody has been subject to discrimination. So if they've sacked because they made a complaint of sexual harassment in the workplace, for example, and they've not got 2 years service, then they may be able to bring a claim under the Equality Act, because again, you don't have to have 2 years service, and also you don't have to be an employee. So, you know, workers who are subject to discrimination in the workplace may also be able to bring a claim that the dismissal is actually an act of discrimination. So the unfair dismissal is obviously in one box, but you know, you've got these other potential arguments, either an automatic unfair dismissal or on grounds of discrimination, and that will apply to those who are on probation as well, because as you rightly say, that's often for less than 2 years. It can be, you know, between 3 and 6 months in some cases. In other cases, it can be longer. But this is a real barrier, and you know, increasing it from 1 year to 2 year has caught a lot of people out. But you know, there are these other avenues, as I say. You're looking at automatic unfair dismissal or a potential discrimination argument.
Thanks, Jo. So, Gerard, we've had a question that talks about the remedies for personal injury. Should reps be advising members to claim social security benefits for a potential injury, for example, industrial injuries, disablement benefit, or would this be taken account as part of any payout, or would it make them worse off?
No, if people are entitled to benefits, then they should claim them. Apart from anything else, if they're successful, they'll get those benefits quicker than they will in a compensation claim. Because even if we win these claims, they're not going to settle for at least, I would suggest, 2 or 3 years. So if people need money, quite possibly because of their contraction of the illness, they need to be making claims as soon as possible. IIDB, I know that it's a bit of a fraught question. I know that the IAC have made some temporary adjustments to the normal list of prescribed diseases in relation to COVID, and so you know, it seems if you can show that it's likely that you contracted the disease through work, then by all means, I think people should make those claims. At the end of the day, if there's a loss of earnings claim in the personal injury claim, then the amount that they will receive for benefits will be offset against that, against their loss of earnings, and the insurance company or the compensator on the other side will have to pay the government back for the benefits received. But yeah, people should make claims if they think they're entitled to them.
That's really helpful. Thanks, Gerard. So we've had quite a few questions about anything that comes under casualisation of work, 0 hours contracts, that sort of area. Can you say anything, Jo, please, about this and giving the increasing casualisation of work? What can we do about unfair dismissal when the usual tests sort of almost don't apply? Is there anything we can do about that, please?
Well, I think if I just perhaps explain about what you have to be an employee. I mean, in some cases, in order to be an employee, you've got to be engaged on a contract of employment. So the question is what is a contract of employment? And I think there are 3 key tests really for determining whether or not somebody is engaged on a contract of employment. The first is the requirement to provide personal service so that the individual is actually doing the work. The second is that they're under a degree of control. So the employer decides, you know, they pay them, they decide what the work is. They might not decide how the work is done, that might be down to the individual, but the employer ultimately determines, you know, they've got control over the work that the individual is doing. And the third is that there is mutuality of obligations. Now, this is the tricky bit. This is the real big hurdle to get over, to demonstrate that you are an employee and therefore qualify for the benefits as an employee. Essentially, what this means is that there is an obligation on the employer to actually offer you work, and there's an obligation on you to accept that work. And it boils down to whether or not there is a genuine ability on the worker to refuse work. And that, you know, that's where the real battleground is. That's where the battleground's been in Uber and various other, you know, cases about whether or not there is mutuality of obligation. So I hope that gives some idea of what you need to show in order to be able to demonstrate you're an employee. And again, it goes back to, you know, workers do have rights too. So you might not necessarily be able to satisfy mutuality of obligation, but it's something quite similar, in which case you might be a worker and then you would be entitled to, you know, the rights to, you know, time off for trade union activities, or you might be entitled to holidays under the working time regulations, etc.
That's really helpful, Jo. Thank you for that. We've rapidly sped through almost an hour of webinar. It has been incredibly helpful and useful. I don't know whether you've seen any of the comments that have been flashing past. People were saying that they have to go because we said we'd be done within 45 minutes, but we're still going. And people are saying it's been really helpful, and they're going to encourage their other workplace reps to watch the recording and to read the transcript. One thing to all viewers, we've had a huge number of questions. We've not come anywhere close to answering them all. So I'm thinking what we'll try and do is take a note of everything and see if we can work with Thompsons again to maybe answer some more of those at a future event. So please don't think that your questions are just being ignored. We will take a note of them. So all that remains for me to do is give a really big thank you to Jo and to Gerard for joining us today. And thank you to all of you for joining us, because you've been fantastic with your questions and with your interactions. Please do remember that as workplace reps, if you do need legal advice, to consult your union, because they will be able to help you with that. They may well put you in touch with Jo or Gerard or one of their colleagues. So don't forget to do that. Please do tune in again. Our next webinar is a week today. It's on the very current subject of ventilation at work. We do hope as many of you as possible will tune in for that. So thanks again. Thank you, Jo. Thank you, Gerard. And have a good day, everyone. See you.
Thank you. Bye.